Ms. Collier, if you'd like.
Thank you, Mr. Chair. I will take a few minutes. Starting with Mr. Ottley's comment that the reliance is strictly on the city attorney. As this board knows, that's far from the only reliance. You are in possession of a 10-page written opinion from Glenn Wasserman, who was your outside counsel at the time that this application was filed, and outside counsel at the time the agreement affecting real property was drafted. In fact, he drafted it in conjunction with Pam Hamilton. His opinion is on record and matches the city attorney's opinion. You also have the written and oral testimony of Pam Hamilton at your real estate committee discussing the intent and the history of the agreement affecting real property and what it means and what it doesn't mean. And finally, you have the testimony of Peter Janapal, who was the other party to the contract at the time. The notion that everything has been rejected by Judge Nevitt, I think, is a little disingenuous. I'm also not a trial attorney, but we're talking about a pre-demurrer stage procedural motions, and if that's going to be declared victory on the merits, I don't think that's accurate. And finally, the notion that you would simply wait till a final decision through trial and through appeals before you move an inch, I think has already been rejected in general terms by this board. But I would also observe that if we continue to travel at light speed through the Planning Commission and City Council and get through them in January or February, and then we rush to get development drawings done and financing in place, and the market turns around, and we could actually stick a shovel in the ground at the most optimistic time would be fourth quarter 2008 or first quarter 2009, which is a year and a half away. If at that time a trial court viewed the other side as winning on the merits, that would be the appropriate time, or there would be irreversible harm by going forward, by digging a hole in the ground, and that's the appropriate time to consider that. But if we're simply going to stop everything just because a lawyer has convinced a party that they have a viable lawsuit, I think that would be bad precedent for lots of other projects. I was a little perplexed by Carol Eisman's comments. First, it wasn't a $17 million loan, it was a $6 million loan, and it was paid back early. And the contractual obligation to the homeowners was that a building was going to be built on this parcel, and you've seen the disclosures. It literally hit them over the head. And I'm glad she mentioned the CC&Rs, because it's in the CC&Rs. The development of Parcel 2 may temporarily or permanently interfere with and or alter the use of areas within Parcel 2, including without limitation the swimming pool, the parking garage, and other portions of the association property. The board shall be entitled to enter into such cost-sharing agreement, etc. The development of Parcel 2 may negatively impact and obstruct existing views from units within the project. That's the only mention of Parcel 2 in the CC&Rs. There's no mention of 2025 in that paragraph or any other paragraph in the CC&Rs. The agreement affecting real property does not say development will not happen until 2025. It specifically contemplates the opposite. And the disclosure documents are literally absurd. And everybody in this room who lives at El Cortez, just in case they want to see their own signatures, I can show it to them in the stack. And I guess finally, with respect to Mr. Bruin's comments about the Planning Commission, I would really encourage them to watch the tape of that hearing from April 2004. In one of my PowerPoints, 3 or 4 presentations back, I transcribed an exchange between Carolyn Chase, then a commissioner, and the staff, specifically calling out that they were consolidating, not splitting. They were consolidating 12 lots into 2, and that there would be specific and separate development rights on that second lot that would go through the normal process. Certainly the Planning Commission understood that. It was explicitly articulated, and immediately after that conversation, Carolyn Chase made the motion to approve the condo map. I would also note that, but for the other changes to the condo map, that's something that could have been done ministerially and didn't even require a public hearing. And with that, I think I'll resist on the rest of the laundry list and appreciate the board's time once again, and thanks for your consideration today. And if you have any additional questions, we'd be happy to answer them. Thank you.